viewers, welcome to another edition of Legal Hour. My name is MC Chaka. I'm your host for this educative program that we bring to you every Tuesday from 8:30 p.m. London time. Tonight, I'm going to be here with my usual guest, lawyer Thomas Beyebenwo. Lawyer has been an incredible person, and always he comes here with us to educate the public about various aspects of law. Tonight, we've got a lot to talk about. Interesting topic to discuss tonight. We're going to talk about housing disrepair claims. A lot of people in the UK, most especially, have been impacted by housing disrepairs. Tenants are suffering, landlords are not being truthful, and they're not obliging or complying with what they're supposed to do. So this has caused a lot of havoc and a lot of issues between tenants and the landlord. Tonight, lawyer is going to tell us our rights, the process, and everything that we need to know in respect to housing disrepair. I'll be introducing lawyer very soon, but please, before I introduce lawyer or before I bring lawyer on board, make sure you share this program. The link has been already given. If you go to YouTube, Solicitor Thomas Beyebenwo. If you go to Facebook, Solicitor Thomas Beyebenwo. And then also, lawyer has shared to his contacts. I'll be sharing to my contacts very soon. Please make sure when you get the link, you share for everyone to benefit from this important and educative topic that we're going to bring to you this evening. I greet everyone. I'll be acknowledging my viewers. Please make sure you share for everyone to benefit. And then also, our radio version is active. CITI Media Radio. This program is live on radio, so everything that we're doing here in the studio is channeled through the Facebook Live and radio. This is very good because we've taken a lot of time to make sure that our listeners, our viewers will benefit from the topics that we bring. So please don't go away. I'm going to introduce Leah very soon, but until then, stay tuned. I'll be right back. Please don't go away. Viewers, welcome back. CITI Media Online. CITI Media, this is the topic, Legal Hour. I'm here with lawyer Thomas Beyebenwo. Lawyer, welcome to the show.
Thank you.
How are you doing tonight?
Very well.
It's always amazing to have you on board. I mean, and we are very grateful for the good work that you're doing for the Ghanaian community.
Thank you. It's not just the Ghanaian community. I'm sure that a lot of people have been contacting us and full of praise for all the stuff we'll be doing. We have Nigerian community. We even have English clients who have been watching us. So it's a very good program for all and sundry.
That's right. So tonight we've got a very interesting topic, housing disrepair. This topic, I mean, when I saw it, I was like, wow, because a lot of people, we are having issues at their various homes, tenants, landlords having issues. So, I mean, what propelled you, what motivated you to obviously bring this topic on board that we should discuss this evening?
Yes, I'm sure that people that have been following us for some time now are already familiar with the passion that I have for this profession, and especially the underdog. And it's not in dispute that a lot of people are in a house that in a very terrible state. They've been paying rents, and in fact, some of these houses are even owned by local authorities. So it's not just private landlords that are sometimes perpetrators of some of these things, but even local authorities who are housing tenants or who have given secure tenancy to some tenants are also sometimes reluctant to undertake the repairs. So a lot of people have been experiencing these problems. And most importantly, sometimes when people are in this disrepair accommodations, they are entitled to be on a priority list. So I'm sure tonight, by the time we go through these programs, people know their rights. My passion is for people to know their rights.
Okay, yeah, that's the passion lawyer has. That is the reason why we always bring in this program, to make sure that people know their right and obviously familiarize themselves with the policies that underpins these aspects of, I mean, their lives. So, lawyer, I know housing disrepair comes under some legislations. As a practitioner, what legislation underpins housing disrepair?
Yes, we have the Home Fitness for Habitation 2018, and we have the Landlord and Tenants Act 1985. So the Homes Act has amended some sections of the Landlords and the Tenants Acts. And in fact, we also have the 2004 Housing Act, which also came into effect in 2006, which has given a lot of powers to most local authorities. And that's why we have the environmental agencies, we have introduction of licensing systems for landlords who to ensure that they comply with certain requirements in terms of avoiding hazards for tenants and all those stuff. So we have three main legislations. And in fact, when it comes to some of these claims, we even have the Defective Premises Act, which is an old act, 1972. And then we have the Occupiers Liability Act, 1957. We have numerous legislations that people could rely on to make compensation claims against landlords when houses are in disrepair state.
Well, thank you very much for, I mean, exploring and throwing light on the law. Because I really enjoy or like legal aspect of everything. Because when people wants to know their right, it should be something that be part of the policy. So I appreciate the fact that you've taken your time to giving an explicit introduction or explicit information in regards to the law that underpins or that regulates housing disrepair. That's fine. So what are the landlord duties to tenants in relation to housing in disrepair state? If landlord have any duties, what are the duties?
Yes, as I've said, the Homes Act 2018, which came into effect in 2019 March, brought in some amendments to the Landlords and Tenants Act 1985. So if you look at the section 9A, you will see that landlords have implied obligation to ensure that dwelling houses that are let out to tenants, and when I say landlords here, I mean both private landlords and social landlords, which is local authorities as well. So they have an implied obligation to ensure that the dwelling houses that are let out to tenants are, one, in a very good repair state before they are let out, and they also continue to be in a very good repair state whilst the tenant remains in occupation. So they have this implicit or implied obligation to ensure that dwelling houses are in a very good repair state, or they are fit for human habitation.
That will take me to my next question, mentioning dwelling house and then for human habitation. So in determining whether a house is fit for human habitation, what state of the dwelling house is taken into the account? I mean...
Yes, when we talk about dwelling houses, obviously, when I started this, I talked about the Occupiers Liability Act, I talked about the Defective Premises Act, I also spoke about the Housing Act 2004, and then the Homes Act 2008. And finally, which is the embodiment of this whole thing, is the Landlords and Tenants Act 1985. The fact is that each of these legislations have laid out what should be taken into account when we are considering houses in disrepair state. If you look at the 1985 Act, you see that lighting, drainage system, convenience, places of convenience, drainage in terms of plumbing stuff in the house, and heating, even heating. There are some houses there will be no heating for a couple of weeks. Landlords are not minded to undertake those priorities. That is a breach of the Act. And then when you move further to the 2000 Housing Act 2004, that is the legislation that gave enormous authority to local authorities to enforce where houses are. For example, there are hazards in those dwelling houses. The hazards could be falling roof, it could be serious events like where doors are not well fixed, that people can gain entry, windows falling off. So wiring system not being properly done, that's why you have the electricity certificate and gas certificate. So these hazards also form part of the disrepair state. So when we are looking at houses in disrepair state, we take all these factors in totality into an account. So there are numerous areas that people can rely on when it comes to making claim, to proceed with their claims.
Well, thank you very much for the thorough explanation. I like the way that you're taking your time to explain things and obviously to emphasize on the key points. So let me ask you this quickly, lawyer. If landlords could be exempted from maybe disrepair claim or liability, under what circumstances can they be exempted?
Yes, the starting point is that landlords needs to be informed of the disrepair of those dwelling houses. So tenants also have an obligation to ensure that when houses are in disrepair, landlords are duly informed. And I stress here, they must be able to show, whether by text message or by email or by some letter form, because sometimes I have dealt with cases where landlords have been complete denial of being notified of those disrepair of those dwelling houses. So people need to duly inform them. The other point is that if the landlord, for one reason or the other, also requires permission from another authority, So you notice that there are some people may own flats in a block of flats. So sometimes they also need permission from the landlord of those flats, because whenever people buy flats, they buy it under lease, and the lease may there may be implicit requirement that whenever certain repairs are being undertaken, they require permission from the actual landlord, because sometimes they don't want to disfigure the structure and all that. So under those circumstances, the landlord may be exempted for perhaps delaying the repair or by giving good reason for not undertaking it.
Yeah, lawyer, I mean, let me get this clearly. So, because sometimes I know most of the landlords, they will sign up to an insurance company or something like that to fix some of the things in the property, and they'll be relying on these insurance companies, and we know how long it takes for insurance company to obviously repair things or come to attend to a call house and stuff like that. So can't the landlords obviously put an effort to repair and later claim from the insurance? Because, for instance, if the sink is not working, if we have a problem with the boiler, the heating system is not working, and you're relying on insurance to fix it, it could take ages, considering if there are children in the house. So what can actually be done to enforce or to make sure that landlords attend to repair before they will claim, or they rely on people, rather than for them to say, oh, we are not liable for that, and then obviously we can delay? I mean, what can actually be done in relation to that circumstances?
Well, this is a very good question. Just to clarify, the point I made here is not relying on insurance cover. Is where landlords require explicit authority from the landlord under which lease they are owing the flats, or where they have not been duly informed. But when it comes to issues of insurance cover, obviously the landlord would have had a policy which contains terms and conditions for the fulfillment of those obligations with the insurance company. So if, for example, the insurance has delayed and that has caused, for example, that has resulted in somebody making a claim, then the landlord may also join the insurance company to that claim for breach of their own contract to the landlord. But that should not in any way cause undue delay to the tenant, because the Act is very, very explicit on the fact that landlords have to be able to repair these houses, dwelling houses, in a very, very promptly, especially when looking at everything around, where there are children in the house and all that. So if insurance companies are causing delay, landlord, depending on what policies they have, may also employ a different contractor to undertake the work and make claim from their own insurance for that delay. So that should, in no circumstances, should be a burden on the tenant.
Okay, thank you very much for clarifying that, lawyer. Lawyer, before we continue, let me acknowledge my viewers from Facebook. Viewers, you mean a lot to us. You are the reason why we bring this program to you every Tuesday at 8:30 and Thursdays for the Chief version. So I'm going to acknowledge a couple of viewers that are watching us now. Nana Poku Efriye Patterson, that's Ura. Ura is saying fire. He's giving the fire sign. Ura, thank you very much for the fire. And thanks for Sunday. Thank you very much for coming. Josephine Abuajimanu, Joe is also saying fire. Hi, Joe. Joe is my mate from primary school, JSS, Mampong, Roman Catholic JSS. Thank you very much, Joe, for watching. Please make sure you share to all your contacts. I know you've got a lot of contacts. Make sure you share with them, please. Yeah, Josephine is saying, oh, that's my bro. Nice program, DJ Chaka. Much love. Thank you very much. We love you too, Joe. Cornelia from Pomajima. Cornelia, our #1 viewer. Thank you very much, Cornelia. Lovely evening, Lawyer Thomas, DJ Chaka, and City Law Community Family. Thank you very much. Good evening to everyone watching us right now. Okay, Miranda. Miranda is saying, good job. God bless you, lawyer. Thank you, Miranda. God bless you too. Francis Apia Akwe watching. Yana, that's my brother in Ghana. Kwesi Apia. Kwesi, thanks for watching. And my uncle Billy Udru Kwate. Uncle, thank you very much for coming on Sunday. We really enjoyed your company. May God bless you and your family. Thank you. Uncle is watching. Cornelia is advising people to share. Papa Kwajubuatin, DJ Papa is watching. DJ Papa Lupa indicates the papacy. Yes, the big man is watching. Okay, Bobby says, boss, please, my problem is when some of the clients through non-advert pick up, I have advertised you to be best solicitor in our generation. Please continue to help the needy like us. God bless you, Mr. Tom. Okay, thank you very much. I know lawyer has taken note of that. Lawyer, haven't you? Isaac Cole, big man. Isaac is watching. Thank you very much, Ike, for subscribing and tuning in to watch. Tiga Opa Edwards. Tiga said, keep doing good, solicitor. Keep doing good. Tiga, thank you very much for your words of encouragement. DJ Papa is saying, continue your good job to our society. Thank you, Papa, and thanks for coming on Sunday as well. So viewers, our topic is housing disrepair claim. A lot of people have gone through this. Tenants are not doing what they're supposed to do. Landlords are not doing what they're supposed to do. So tonight is very important. If you have problem with your things in the house, you know exactly who to contact, when to contact, and what you need to do to obviously resolve their problem. So let's continue with the questions. So in terms of housing disrepair, can tenants also breach something that will obviously not make them eligible for repair? Can there be any breach in terms of them not complying with the tenancy agreement or anything of that sort? What could be some of the breach that could happen?
Yes, thank you very much. This is also a very good question. And I remember this is somewhere last year. I think somewhere last year I dealt with a case of that nature. This was to do with, not necessarily disrepair, but to do with the Housing Act 2004, when landlords are meant to have a license for houses in multiple occupation. And under those circumstances, if, for example, somebody brought in another person that was not on the tenancy, then that could be a breach of the tenancy agreement. So when we look at disrepair, for example, I've already set out some of the reasons that landlords could be exempted. For example, if the landlord has not been duly informed of the disrepair state of the house. And obviously, when people also enter into tenancy, they also, as tenants, they also have obligations. Some of the obligations might mean that they cannot bring in other parties to come and live in the house. So let's say, for example, if someone has rented a house or a flat that is meant for just himself and the girlfriend, and then maybe he ended up bringing about 4 people into the house, then under those circumstances, if there is a lot of damages to the house, then the landlord may reasonably argue that it is that particular tenant who has brought in all these people, for example, drainage system, always having issues here and there. But even that, this is also subject to the Consumer Right Act 2015, which will be looking at the fairness of those terms that the landlord has included in the tenancy. And again, those of you who have been following us for some time will be very familiar with the Consumer Right Act, which is more like a Bible. Once you could, even landlords can also...
I remember that. Okay, so assuming I'm a tenant and I've breached the rules, is there any chance, or can I still make a claim? I mean, under any circumstances, even though I've breached the rules and regulations?
I like the fact that you ask very sensible questions. Yes. The fact is that when I started this discussion, I mentioned about 4 legislations. They are all distinct in nature that allows people to make different claims depending on their circumstances. So it's a very good question. When you look at the Defective Premises Act 1972, which means that those landlords own a duty of care to anybody that is in that premises. So even somebody who is a visitor that came into the house to sleep there for a while, if that person has suffered injury because maybe there is the roof falling off or there are wires hanging around, that the person may have suffered some shocks or injuries, or the floors are not well prepared, and that has caused some injuries to people. Even in the garden, where the gardens are in a very bad state and somebody has fallen off, and that person is arguing that is the disrepair state of the house, then that person could reasonably rely on the Defensive Premises Act 1972 to make a claim. So landlord cannot just simply exclude liability by saying that the tenant has breached tenancy by bringing a third party.
All right. Thank you very much, lawyer, once again for that thorough explanation. Comments, your question is really important, and I'm going to ask lawyer right now. Comments is saying, if a landlord refuses to fix anything broken, for example, the boiler not working, can I fix it myself and send the landlord the bill? That is from Kofi. That is a very important question.
Yes, that's one of, it's a very common question. Yes, as I've said, under the Act, when there is a disrepair, the tenant's duty is to duly inform the landlord of that disrepair. The landlord then has obligation under Section 9A of the Landlord and Tenants Act 1985 to repair that dwelling house or whatever part of the house that's in repair. So if the boiler is not working, boiler forms part of the hazards under the 2004 Housing Act, and again under the Section 10 of the 1985 Act. So it forms part of the drainage system or the heating system. So if the landlord fails to repair it after you have duly informed the landlord, you have two courses of action. One is to inform the landlord and put the landlord on notice that if he doesn't repair the boiler, then you can bring in someone to come and do it, and then you send the invoice or make deduction from your rent when it's due. So you don't have to wait on end for this landlord who is refusing to fulfill that obligation. And under some circumstances, the environmental health could also be informed about it, where that is posing a risk to children in the house. And again, that is the stage where the person will be moving towards making a claim of compensation against the landlord.
That's great. Comments, I hope your question has been answered. Thank you very much, lawyer, for that. So, if landlord has an obligation to repair, what is the minimum time they can give to tenants before that work can be undertaken? Because the issue is that sometimes it could take forever, and we will bring our repairers, we will bring our engineers. It could take ages, but then some of them needs to be done imminently. So what is the minimum period of time that obviously could be set for them to fix whatever is new to be repaired?
Yes, landlords, once they are duly informed of the disrepair state of that dwelling house, then they have 24 hours. They have to give 24 hours notice to that tenant, and then within that period they need to come to the house, the dwelling house, to assess the disrepair. The point is that they have to assess the disrepair by giving 24 hours notice to those tenants in occupation. And this serves two purposes. That means that landlord cannot simply just barge into the house without giving notice. And then that also gives an obligation for them to also, within that 24 hours of giving that notice, also to come and assess the disrepair state of the house. And then from that point, they need to engage someone to undertake that repair. And that has to be done in a very reasonable time.
Okay, thank you very much. So if you're watching us, viewers, we're talking about housing disrepair claim. I acknowledge my listeners as well, because this program is on the radio, CITI Media Radio, and I know a lot of people are listening to us. I've got a lot of messages from my contacts that they're listening to this program and they're enjoying it. Thank you very much for tuning in Modern Ghana the abroad section. That is where you can get CITI Media Radio. So please enjoy both sides, either Facebook or the radio. You will still benefit and enjoy the program. Lawyer, this question is really, really important. You know, if tenant sustain an injury due to disrepair state, if there's an injury, maybe it has been reported to the landlord, it's not been done, and as a result of that, the tenant has sustained an injury. What are the circumstances, or what sort of claim can be done, obviously, for the tenant to benefit from the injury or to claim as a result of the injury that has been sustained?
Yes, I think somebody has already asked this question. The point is that when the house is in disrepair, or the dwelling house is in a disrepair state, then tenants have various ways of making their claims. And let me make this distinction here. The distinction I'm making here is that depending on the individual's relationship with the landlord, then that person will rely on different legislation to make their claims. So let's start with tenants. Now, if tenants have sustained injuries as a result of the disrepair state of the house, they have the right to make claims under the Homes Act 2018, which has amended the Landlords and Tenants Act 1985. So that's for tenants. Now let's look at your friend who visited you in your house, and he's not a tenant. He has not signed tenancy agreement with the landlord.
Yeah.
So that person is somebody who does not have a legal relationship with the landlord. That person can rely on the Defective Premises Act 1972 or the Occupiers Liability Act 1957 to also pursue a claim against the landlord for the disrepair state of the house.
All right, thank you very much. I mean, I like how you're taking your time to obviously go and bring the legislation or the law, in your explanation or sessions. That is very important. So viewers, we know what exactly to do. If, let's say, your carpet, your tiles, something needs to be fixed, and unfortunately they've not done it, and you slip and you injure yourself, you can claim as the lawyer has advised. So please, if you're looking forward to claim all sort of claim in terms of housing disrepair, please make sure you contact legal CITI Law Solicitors. CITI Law Solicitors. CITI Law Solicitors is #1 law firm in the UK. Lawyer, can you tell viewers where you are based, your address, the location, and the office telephone number? We will repeat this constantly because I get a lot of people calling me asking, can you give us the office number? For some reasons, I might not be able to give you lawyer's personal number, but please take note and write down the office number for all your claims, housing disrepair. If in case you are eligible for a claim, please make sure you contact lawyer. If you are not sure, please make sure you contact CITI Law, and they will be there to support you with all your claims. Not just that, all legal matters. It could be immigration, clinical negligence, it could be employment, it could be housing, anything, media, any aspect of law. They are there to support us. So viewers, lawyer is going to give us the number, the office number, and give us the address or directions to the office so that we can contact them for any sort of claim, housing disrepair. If your landlord is giving you a headache in terms of not fixing whatever needs to be done, you can always contact them and they'll be there to support you. Lawyer, are you ready?
Yeah.
Okay, so viewers, the number will appear on the Facebook comment. The address and everything will appear on the Facebook comment. The office number is in London anyway, so it's 0203 355 0782. I repeat the number, 0203 355 0782. So this is the office number, and the address is number 50 Cambridge Road, Barking, IG 11 8FG. number 50 Cambridge Road, Barking, IG 118FJ. So this is the office address. Please make sure you keep it, and then the contact number as well. For all your legal matters, make sure you contact CITI Law Solicitors. Lawyer Thomas and his learned colleagues are there to support you with all your legal matters. So please don't look anywhere further. That is the reason why we bring this program to you, to make sure that you enjoy to the maximum finality, and also to make sure that all your legal matters get resolved. Anyway, lawyer, we continue with the questions. But before that, let's take a quick commercial break. I know you've spoken a lot, because we're going to revisit some of the topics that you've already questions that you've already covered. So a quick commercial break. We'll be back. Please don't go away. Stay tuned. We'll be back shortly. Thank you. Viewers, yeah, that was quick. As I said, we are back, and we're going to continue with the questions. So the topic is housing disrepair claims, how we can make our claims when landlords are not doing what they're supposed to do. So this is very important, and I hope you shared for your viewers, your contacts, to obviously benefit from this program. Let's continue, lawyer. So I know you've covered certain aspect of this question, but I still need you to throw some light into that. Why is it important for tenants to complain about disrespect to their landlords? Why is it really important for them to do that, tenants?
Yeah, that's one of the very good questions. If I recall very well, I think, as I said last year, I was dealing with a case, like I think it's this year, beginning of this year, house in multiple occupation. And some of these programs we are doing here, we are preparing people to know their rights. And in fact, when I was dealing with that particular case, slightly different from what we are discussing here, but that also comes under the Housing Act 2004. And the fact is that the landlord has rented out a house to a family, 2 families. The landlord didn't have a license. But the landlord turned around and said that he was not aware of the presence of the other parties in the house, because he doesn't come to visit the house. So my client was supposed to prove to the court that he has duly informed the landlord that they are overcrowded in that house, and the landlord was supposed to act. And because he normally talked to the landlord, he didn't have any text message and all that, the landlord was able to exclude himself from that obligation. So the fact is that when people have disrepair in the house, it is so important that they inform the landlords about those disrepair or the disrepair state of that dwelling house. Because if you don't do it, then the landlord can say that he's not aware. Then under those circumstances, even if you bring a claim to the landlord will be exempted for not being aware of that disrepair state of the house. And sometimes talking to the landlord over the phone might not be enough. Text message these days can be acceptable. You can print it to show that, look, this is the date that I informed you. So it's so important that people do inform landlords when the houses or dwelling houses are in disrepair state.
Thank you very much, lawyer. So we all know it's very important that we need to inform the landlords when we're living in houses that are in disrepair state. I'll continue to acknowledge my viewers. I've got a couple of people that have just joined. Kofi Wuzi, Kofi say Luchi Beyo. Yeah, Kofi Luchi Beyo. What is the meaning of that? Anyway, Obibini Techi, lawyer, I think you are wearing two hats, pow. Obibini, I can't really get your question right. Yeah, DJ Master P. Master P is watching, one of our best DJs in the UK, DJ Master P. This TV is moving forward massively. Thank you very much, Master P. It's because of your encouragement and obviously motivation. That's why it's moving forward. So keep watching, keep sharing, and we hope to be more ahead of what we even anticipating. I've got two sway. Prince Atakra Nyamiche. Prince Atakra Nyamiche is watching. Nana Ajele, good understanding. Thank you very much, Nana. Thank you very much. So yeah, Mr. Leboko is listening to us live on the radio. DJ Papa is watching. Ura is watching. We've got everyone that obviously come with us and understand the topic. And this topic that we've selected today is really good because everyone can be in that state. Everyone can be in that state. Housing disrepair is something that affects everyone. For instance, myself, lawyer, I have been, calling my, the estate agent for ages. I've been calling them to change the carpet because it's part of the tenancy agreement for them to change it. And they've been postponing all the time, procrastinating. Oh, we'll come today, we'll come tomorrow. So I've taken a lot from tonight's topic, and I understand exactly what I need to do and push them forward to obviously make sure that they attend to fix it. I'll keep on writing to them. I'll keep on calling them as you've obviously advised. So thank you very much for throwing very good light, into these areas of our life because it's something that we need. The council, they have a duty to support. They have a duty to repair. Private landlords, they have a duty to. So what lawyer is saying is applicable to everyone, whether your tenancy is through the council or private. So please make sure you take note of that and obviously enjoy making claims if they are failing to do whatever they have to do. Lawyer, back to my questions. So, people that are living in accommodation that is unfit or not conducive for human habitation, do the council have any duty or any right to support them with accommodation?
Yes, this is also a very, very good question. We all know that most of the councils have a policy where people have to be on the housing register. And this policy has been introduced by a lot of local authorities. And that register, before somebody will be offered either temporary or permanent accommodation, has to be considered based on that person's circumstances. And most people will be familiar with what we call the priority list. Therefore, if somebody is in a house that is in a very disrepair state, that person has a right first to complain to the local authority. And I must admit that it's quite difficult, saying this thing theoretically, but I have even had clients that I'm still dealing with matters of this nature. So that person has first to inform the local authority. The environmental agencies can get involved. Normally, when the environmental and health agencies get involved, they will assess the disrepair state of the house, and they can come to the conclusion that it is not fit for human habitation. Now, under those circumstances, the landlord will be notified, and again under the Housing Act 2004, the local authority have powers to prosecute those landlords. So that's one point. The other point is that both under the Children's Act Section 17, and also the fact that those people are living in those local authorities, the local authority has a duty to provide those people with a befitting accommodation. So while they have the powers to prosecute those landlords who have failed in their duties to ensure that those houses are in a very repair state or fit for human habitation. They also have a duty to provide alternative accommodation for those people who are suffering or who are living in houses that pose risks to their health. So it's under those circumstances that those people can get accommodation from the council.
Okay, lawyer. So if the council have agreed that obviously there's something going on, I think there's a lot that will take into consideration to make sure whether you are entitled for let's say social housing, because they take a lot into consideration whether you fall into the priority need. I mean, all these will be taken into consideration, but the most important thing is that if it's a private tenancy, that you've got, and the issue has not been resolved with the landlord or the people that rented the property to you, can you liaise with your council, your local borough, and report it to them? And do they have a duty as well to support you, even though your tenancy is not provided by the council?
That's right. That's exactly what I said. The local authority, one, has already said that when people have living in those dwelling houses which are in a very terrible state, they have a duty to report to the landlord. Landlord will sometimes fail to undertake those repairs. They have a duty to also inform the local authority, which is the environmental health department, who will get involved and assess the hazards in the house. Now, when those people who are in those private accommodations, that in a house that is unfit for human habitation, and all efforts has failed to persuade the landlord to put that house in a habitable state. Then, as I've said, those local authorities have powers under the Housing Act 2004 to prosecute them, but they also have a duty to provide befitting alternative accommodation to these people. Because remember that whenever local authorities are assessing the priority needs, they take overcrowdedness into account.
That's right, yeah.
They take the fact that the person is homeless. And remember that if the landlord has refused to undertake those repairs and that house poses hazard to you, you are more or less homeless because you cannot live in that house.
That's right.
So that moves you straight onto the priority list. But the danger is that because there are less housing stock, most times local authorities will be shirking their responsibility. They will be delaying in terms of pursuing the landlords to do it. But the fact is that they have a duty to provide that accommodation. And I know that a lot of people who are in this situation that do not know that that situation they find themselves in put them on the priority need for the local authorities to consider them.
Okay. All right. So viewers, if for instance you live in a place, whether private or council tenant, and then your landlord, if they are not doing what they're supposed to do, and where you live in is not conducive for human habitation, that means where you live in is not a place that is fine or is well presented or is nice for you and your family to be living there, the landlord will have an obligation to do it. But if the landlord fails to do it, you can report, you can escalate that to the local authorities, and they will be having obligation to support you either by pursuing the landlord or giving you a suitable accommodation. Thank you very much, lawyer, for that explanation you've given as well. So my next question is, we live in certain areas, we know same places, they have bed bugs, they have mice, they have cockroaches, a lot of things that obviously pests all over, which is not, makes the place very uncomfortable and not conducive for human habitation. So sometimes I know the landlord might say it's your responsibility to deal with that. What are the tenants' rights, and what are some of the remedies that can be put in place to make sure that the tenants get what they need from the landlord?
This is a very interesting, question. So I liked the way you pose this question because it enables us to cover all aspects of this disrepair.
Yep.
So when you have pets, rodents, and bed bugs,
cockroaches.
Then
Sometimes there could be rats, the big ones.
So when you have all this stuff in the dwelling house, then we are slightly moving away from perhaps disrepair. So this becomes environmental hazard.
Okay.
So it's also possible that because of the disrepair state of the house, that's why the mice infestation or cockroach and all that. So it's possible that because of the disrepair state, but it's also possible that it might not be associated with the disrepair state of the house.
Lawyer, I don't mean to cut you. Sometimes same places that the windows are single glazing.
Yeah.
When it's winter, you see there are moles on the walls. Yeah, yes. And then you see the moles. They can lead to all these bed bugs. They can lead to these pests coming out in the living rooms and stuff like that. That's the reason why I posed this question. So, what are the remedies? What right do tenants have, obviously, to get landlords to solve all these problems for them? Are they not required to bring maybe the pest control team to spray the property, or are they not probably meant to change something? Maybe the carpet is there, it's been there for ages. So that is why I pose this question. So what are the remedies? What can they do, obviously, to resolve this problem?
Yes, it's quite a good question, and that's why I was taking my time to answer.
You have all the time.
Yes, yes. You mentioned mold. Remember when I set out the discussion, if you look at the section 9A of the Landlord and Tenants Act 1985, mold forms part of the state of the disrepair of the house. And if you look at the Housing Act 2004, Section 2, you will see that mold also forms part of the hazards. So the point is that if there are molds, it's part of the disrepair that the landlord needs to undertake. But if you move from molds to mice infestation, bed bugs, cockroaches, then that becomes an environmental issue. So those people, their first remedy is to inform the council, the local authority, environmental health department. They will come to the house to assess the level of environmental hazards that those people are undergoing. And remember I mentioned that under the Housing Act 2004, the local authorities have been empowered to prosecute those landlords whose houses are in those states. So they can be prosecuted in the magistrate court to even have criminal convictions for putting that house in those states. And obviously, if those people have also suffered some illness, then they can also make claim under the Homes Act 2018, for the fact that they have suffered some injuries. So it was one of my clients that I'm currently dealing with. Getting to the stage that we'll probably have to start a claim. Obviously, depending on the person's relationship with the landlord, sometimes you need to show evidence. For example, you go to a GP to show that because of the mice infestation or because of the bed bugs, you are having some illness or here and there. So those evidence will form part of your claim if you were to bring a claim against the landlord.
Thank you very much, lawyer. Thank you, viewers. So if you just watching us, we're talking about housing disrepair claims. It's time to open the phone lines for those who want to share their views, who want to talk about areas of housing disrepair, or even any other area of law that you need some answers. Lawyer is ready to answer all your questions. So please call. The number to call, the studio number is 07932 934518. 07932 934518. 4518. The second studio line is 0744 033 8623. 0744 033 8623. So we're discussing housing disrepairs and the rights for tenants, obligations for landlords. And lawyer has been very explicit in telling us or throwing some lights in every aspect of housing disrepair. Thank you very much, lawyer, for your generosity. We can always count on you. Lawyer Thomas Beyebenwo is from CITI Law. So what they do, they specialize in immigration law, employment law, family law, personal injuries, clinical negligence, commercial disputes and civil litigations, housing law, consumer law, media and entertainment law. They are located at Unit 113 Barking Enterprise Center, 50 Cambridge Road, Barking, not too far, about 5 minutes from the Barking train station. And the postcode is IG118FG. The office number is 020 33550782. I repeat, 020 33550782. So you can contact lawyer and his learned colleagues in the office. They are special. They will take their time and address every aspect of your life. You see, sometimes we think we can do it on our own. And this is one example I faced or had today. I had a little bit issue with my car. The light bulb, the back light, one side was completely gone, and I didn't know what to do. So I drove to the mechanic, and as soon as I went there, it took me about 30 minutes to go to the mechanic. And as soon as I got there, the mechanic opened it, and he spent just 1 minute to fix it. And he said, "Oh, you could have done it yourself." And I said, "But I didn't know." You see, sometimes in your quest, on your attempt to fix it yourself, you will end up causing a very big problem. It could have affected the whole general fuse box. It was just a fuse that was taken out. So all he had to do was to push it back in, and the light went working again. That is his specialty. So you have to leave the experts to do their job. When it comes to my field, I'm very competent. I'm very confident in my field. Lawyer is very competent. He's confident in the legal aspects of this country. So please make sure you contact them. And then the phone lines are open. We wait for you to call us. We've got about 5-10 minutes in the studio. The number once again is 07932 934518. 0744 033 8623. Lawyer, whilst we're waiting for people to call, can you please give us your final submission, brief us on what you've gone through, everything that you've said, just under 2 minutes, please.
Yes, I'm very grateful to everyone who has joined us on this platform. I know most of you are watching on Facebook. Some of you are also watching us from your YouTube channel. And above all, you're also enjoying this program from CITI Media Radio.
That's right.
The only law firm that has brought you radio station for you to be enjoying free legal advice. So please, I entreat you to share the radio station with your colleagues. You can enjoy music and all that. I'm sure DJ will be better placed to advertise that. But let me focus on the law.
Yeah, go on.
Yes, tonight's been a very amazing. I'm sure that those of you who have joined us, you've all learned a lot, including myself. We set out this program by looking at 4 distinct legislations: the Homes Act 2018, which became operational in 2019 March. We've also looked at the Landlords and Tenants Act 1985. We look at the Occupiers Liability Act 1957. We look at the Defective Premises Act 1972. In fact, we've looked at all these 4 legislations, including the Housing Act 2004, which empowers local authorities to prosecute landlords for certain offences and to issue out licenses. And we look at what is a house in disrepair state. We realize that if you look at the house, the heating system, the drainage, mold, And if you look at the Housing Act 2004, you can also look at certain hazards with wires hanging around, doors not being properly fixed, windows in a disrepair state. All these stuff puts hazards. And we also found out that even the garden forms part of the dwelling house. If people sustain injuries in the garden, and it's because it's in a disrepair state, they are entitled to make claims. We looked at those people who are entitled to make claims. We've looked at the tenants themselves and their visitors who can also make claims under the Defective Premises Act, and tenants who can make claims both under the Housing Act 2004 and then the Housing Landlords and Tenants Act 1985 and then the Defective Premises Act 1972. So we look at all these legislation that enables people to make claims. And for those of you who may be having problems with rodents, bed bugs, first infestation, the Environmental Protection Act 1990, I think Section 76, also gives you the right to inform the local, to report the landlords to the local authorities. They will move in swiftly to enforce those areas, and then, if possible, prosecute the landlord for not being able to put the house in a habitable condition. And further to that, you are also entitled to make claim for disrepair, and you'll be entitled to compensation. And for those of you who are displaced tenants, you could also be entitled to as much as 6,100 if your landlord has put you in a situation where you have to be displaced. And recently I have one of my clients who came in. The landlord has offered about 2,000. So the landlord is aware that if he doesn't make some offer because the house is in a disrepair state, the tenant needs to move out of it. He has offered minimum of 2,000, which I told my client that this is too low because the maximum is 6,100. And above all, those of you who have been on the waiting list for life and are still living in disrepair accommodations, you are entitled to be moved straight onto the housing register priority list.
Okay.
But I must caution that local authorities will always find a way around it. And I've also admitted that even dealing with it myself, there are a lot of challenges. And this is why you need a lawyer to assist you in these cases. And people can pursue these claims under sometimes legal aid or a conditional fee agreement. Yes. So this is what we've learned tonight. So people may phone in to ask questions. And then I leave the rest to my only MC with 3 titles, DJ, MC, and the commission officer.
All right. Thank you very much, viewers. Lawyer Thomas Beyebenwo from CITI Law Solicitors. It's been amazing having you on the show and the good work that you're doing, the enormous support that you're giving to the Ghanaian community. We do really appreciate what you're doing for us. As usual, let me acknowledge some new people that have joined the Facebook. So, Mami Ya Afra Kuma, watching live from Wolverhampton. Oh, Mami, my dear sister, long time. Thank you very much for watching, Mami. Thank you. Princess Anai Promzi, hi, watching you live from Accra. Thank you for watching, Princess. Prince Atakura Nyamiche Tiswe is watching from Ghana. Patrick Yeboah, bro, I'm live. Oh. You are providing good ideas. Thank you very much. Thank you for watching. Dennis Adebedu. Okay, Dennis, with your question, I'm sure last time lawyer said there's a bit of jurisdictions, you know. So when it comes to Ghana law and the UK law, they have some sort of differences, and he practiced in the UK. So with this, it might be different how you pursue moving out from or throwing somebody's belongings or whatever from accommodation that the person has been there for over 3 months. It might be different in this country. We have a different law that obviously governs that, you know, needs to go through the court. Eviction notice will come in, and then the court will get the bailiff to obviously move the person out. So this one might be different from the practice in Ghana. So thank you very much for your question anyway. Cornelia from Pomwa. Cornelia says, great insight on today's topic. Thank you, Lawyer Thomas, CITI Law Solicitors. William Boache BM is watching live from Hertfordshire. Thank you very much, Senior. Thank you as always. William is saying nice topic. So yeah, tonight's topic has been very insightful. I've learned a lot tonight, and I know definitely that I will be able to pursue my my landlords. I mean, obviously the estate agent. I'll be able to pursue them to fix whatever needs to be fixed for us. So thank you. Yeah, CITI Media is live. So when we leave the studio, the radio will still be active, and it's 24/7. A lot of activities coming on the radio. Music will be playing, a lot of shows. I'll be jumping on the radio as soon as we leave here for about half an hour, and then obviously we leave for the program to end with very good tunes. So please make sure that anytime we come, you share, and don't forget on on Thursday, Lawyer is coming back here with a tree version. This same topic, Lawyer is going to take his time and is playing it in our local dialect. So for those of us that probably might not be comfortable with the English language, or maybe some sort of deficit in the terminologies, Lawyer will take his time and break it into pieces. As I said last time, when you talk about digestion, is what the breakdown of food into smaller particles. So Lawyer is going to take his time and break it into the tree dialect for everyone to benefit as well on Thursday at 8:30 p.m. So please make it a point and stay tuned on Thursday. Make sure you don't go. The phone lines are open. I've got about 1 minute. If no one is going to call, then obviously the program will be ending successfully. But then thank you all for jumping on board. Thank you for watching. Daniel, Amanfo Kwabena. Wow, very powerful program. Hey, Osafo Nyaminipa. Powerful. Thank you very much. Thank you very much for watching, and thanks for the motivation and everything. So please make sure you share in the future and continue to listen to the radio. Viewers, this is where we draw the curtain. Thank you for being part of this show. It's been very nice, very appreciative to have you on board. I hope next week MC Chaka will catch up with you, but then on Thursday at 8:30, Lawyer will be with you as well. Thank you and have a pleasant evening. Thank you. Stay blessed.